or the regular appeal under section 96 and order 41. The procedure in nutshell you should know. Appeal is provided even against ex parte judgment and decree under section 96. But no appeal is provided against consent decree. And with regard to small causes court, we know that unless it is a substantial question of law, if it is not more than 10,000, no appeal is provided. Now we are also entitled to file the appeal without decree. If you are not able to get the decree immediately within limitation period, the operative, by virtue of amendment to order 20, the operative portion of the judgment will be treated as a decree for limited purpose of filing of the appeal till we get the decree copy. We can file by producing original certified copy of the judgment and decree itself. So, we have to mention the brief facts, appeal memorandum, which you are all familiar with. The format is also provided in the appendix to the Code of Civil Procedure. And more importantly, we have to enclose the certified copy of the judgment and decree. Decree is not there, certified copy of the judgment. The grounds on which you are going to challenge, you have to mention. And whether the appeal is filed within time, Limitation Act. If the appeal is to the High Court, as I have already mentioned to you, 90 days. Whatever may be the appeal, if it is to the High Court, period of limitation is 90 days. Other than High Court, 30 days. So if it is delayed, if there is a delay, either you can invoke section 5 of the Limitation Act or order 31, rule 3 capital A. That also deals with regard to condonation of delay in appeals, whereas section 5 of the Limitation Act deals with regard to condonation of delay in filing application, petitions and appeals, not suits. And then if there is any defect, the office will raise objection, or if there is any caveat, 148 capital A, court is bound to issue notice to the caveator and hear him before granting any ex parte interim orders. If office objection is raised, that has to be rectified. Then there is a difference between an appeal filed before the DJ or civil judge senior division or to the High Court. Even though law does not make that distinction, but by practice it has come into existence. That is, as we all know, some of you are practicing in High Court. For appeals, there is a separate stage as admission. Rule 11 and 12 comes into picture, or 41. Court will look into the merits of the case. At that time itself, court may. But Supreme Court has come heavily on that and had said that as far as first appeal is concerned, under section 96, the court is required to or has got right to reappreciate the facts and evidence on record. Therefore, it has to apply its mind in detail, unlike a second appeal where only substantial question of law should be there. So therefore, you may be seeing now, in view of the Supreme Court judgment, the High Courts are admitting the first appeals invariably, because the first appellate court has got power to reappreciate the facts and evidence. It requires detailed examination and considering all the evidence. Therefore, court will admit the first appeal, High Court especially. But that stage is not there in the civil judge senior division or district court. Even though law does not make any distinction, please remember, Provision is one and the same. All provisions of Order 41 in respect of first appeal applicable to appeal filed before the Civil Judge Senior Division or District Court or High Court. Same, but the by practice in the trial court that stage is not there. As a matter of right, the courts will order for issue of notice to the opposite side. And then interim orders. Rule 5 deals with regard to Order 41. One is stay to be granted by the court which passed the decree. Another is by the appellate court. Both are enshrined in Rule 5 only. So if the appellant or the person aggrieved by the judgment and decree apprehends that the opposite party, for example, suit is decreed, money decree, defendant apprehends that immediately the plaintiff is going to execute and have not yet got the details to file an appeal, including certificate copy, so on and so forth. Under such circumstances, the defendant can move the very same court which passed the judgment and decree against which he is going to prefer an appeal under Order 41 Rule 5, mentioning that he is going to prefer an appeal before the appellate court, for which he wants some time, breathing time. Invariably, the court will grant time and also stay its own judgment and decree for a limited period, 30 days normally, invariably. So once the time of stay is over, then he has to move the appellate court, invoking again Order 41 Rule 5 of the Code of Civil Procedure. So Order 41 Rule 5 makes it very clear, as far as recovery of money is concerned, it cannot give a blanket stay order. It has to put some terms as far as money decree is concerned. You furnish the security or deposit some amount, then only the court may grant the stay. Now, other important provisions with regard to appeals is, or if the appeal is dismissed for non-prosecution, please remember, the appellate court cannot dismiss the appeal if the appellant is absent on merits. Whereas, if the respondent is absent, court can proceed to hear the appellant and pass the ex parte judgment. And if the ex parte judgment is made or the appeal is dismissed for non-prosecution, we need not go to Order 9. Order 41 itself has got provision, Rule 19, for seeking restoration of the appeal which has been dismissed for non-prosecution. And similarly, if he has been, without hearing the respondent, has been disposed of or allowed, respondent ಕೇಳ್ದೇನೆ ಮಾಡಿದ್ರೆ ex parte, respondent has got power, right to seek for hearing, permission to hear him. Invariably, the court will pass that order also. And then Order 20, Rule 22 and Rule 27 of 41 are most important, including Order 33 also. So 27, this is the question they have asked. What are the circumstances under which additional evidence is allowed in appellate court? Answer is Order 41, Rule 27. For next question, what are the grounds for remanding the case by the appellate court? The answer is Order 41, Rule 23 and 23 capital A. Another important rule, Order 41, Rule 22. It says no appeal can be filed against findings. There is a drawback for the person who got the relief, but there are certain adverse remarks. Findings are there against him that he cannot question by filing an appeal. To make it clear, in a suit for recovery of money, the defendant put forward that he has repaid the amount. Plaintiff led the evidence, and ultimately the court held that defendant has failed to prove that he has returned the loan amount. The finding is in his favor, defendant favor, on favorably. But the suit is dismissed. Court also gave a finding that plaintiff has proved that defendant is liable to pay him the amount, 5 lakhs. But the suit is dismissed on the ground of limitation, invoking section 3 of the Limitation Act, even though the defendant did not take up that plea. Court said it is barred by time, and rightly the court has got power, as we all know that even though the defendant has not raised the plea of limitation, court itself look into. Now see the irony here. Now the plaintiff cannot file the appeal. Sorry, defendant cannot file the appeal. Defendant cannot file the appeal against the finding that court has held that he is liable to pay. But suit is dismissed. So the plaintiff can file the appeal, but his suit is dismissed. So then Order 41 Rule 22 comes to the rescue of the defendant in case the plaintiff files an appeal. It says if the plaintiff has filed an appeal, in that appeal, the opposite party can file a cross objections with regard to findings also, or cross appeal. You can term as all cross appeal also. Cross objections, Order 41 Rule 22, which has to be filed within 30 days from the date of receipt of notice in the appeal by the respondent. ಆ ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಮೂಲಕ ಅವನು ಅದನ್ನು ಫೈಂಡಿಂಗ್ಸನ್ನು ಚಾಲೆಂಜ್ ಮಾಡ್ಬೋದೇ ಹೊರತು ಫೈಂಡಿಂಗಿಗೋಸ್ಕರ ಅವನು ಸಪ್ರೇಟ್ ಅಪೀಲ್ ಹಾಕೋದಕ್ಕೆ ಬರೋದಿಲ್ಲ. ದಟ್ ಈಸ್ ಇಂಪಾರ್ಟೆನ್ಸ್ ಆಫ್ Order 41 Rule 22. Now coming to this question, additional evidence. The appellate court has got power either to allow the appeal in its entirety by setting aside the judgment of the trial court. Second, the appellate court can dismiss the appeal, confirming the judgment of the trial court. The third one is the appellate court can remand the matter by setting aside the judgment and decree for fresh trial. Or it can also frame an additional issue and send the matter for fresh trial, including that additional issue. So all these powers are available to the appellate court, depending upon the facts and circumstances of the case. Similarly, when the appellant wants to produce additional evidence in the appeal, he has to invoke Order 41 Rule 27 of the Code of Civil Procedure. It mentions under what circumstances he can be permitted to adduce the additional evidence before the appellate court, Order 41 Rule 27. Where the trial court has refused to accept his evidence which has been produced in the trial court, ಕೆಳಗಡೆ ನ್ಯಾಯಾಲಯ ಅದನ್ನು ತಿರಸ್ಕರಿಸಿರುತ್ತೆ, refused to receive the evidence. He wanted to produce a document, court refuses, no, it cannot be. Or the document which he was not able to produce or evidence Even witness ಆಗಿರ್ಬೋದು, not necessarily document. If you could not examine a particular witness in the trial court for a cogent reason or produce a particular document which is very crucial to decide the real controversy between the parties, then also you can invoke Article 41 Rule 27 in the appellate court and produce those documents. ಮಾಡಬಹುದು. Or the court itself, appellate court itself can direct the parties. Now you produce this document. So under these circumstances, the additional documents or additional evidence can be allowed by the appellate court. So when the appellate court allows that application, and whenever such an application is filed, the court is required to dispose of the application along with the appeal. When it is allows such an application for additional evidence, the appellate court itself can record. It is not necessary for that person it should be remanded, no. For example, civil judge senior division or district court, the court itself can record the evidence if it allows the IA filed under Article 41 Rule 27 additional documents. ಮಾಡಬಹುದು. Or else, if it feels that it is not proper, then it can remand the matter, directing the trial court to give permission to the party to lead additional evidence. And Rule 33 is very powerful. To the appellate court. It is like Order 7 Rule 7 of the Code of Civil Procedure, where we have seen the court has got power to grant relief or mold the relief. Similarly, Order 41 Rule 33 gives such a wide power to the appellate court to grant the appellate any order under the facts and circumstances of the case, under invoking Order 41 Rule 33 of the Code of Civil Procedure. So, next, what are the grounds for remanding the case by the appellate court? So, as I already said, either the court, when it feels the trial court has not properly appreciated the evidence on record, it can remand the matter for, or additional evidence is allowed, or additional issue is framed. If the trial court has not framed the issues properly, then also it can be remanded. But you have to make a distinction between Rule 23 and Rule 23 capital A. Rule 23 of Order 41 comes into picture when the trial court has dismissed the suit on a preliminary ground. For example, no cause of action, barred by any law. Order 7 Rule 11, plaintiff is rejected. Suit is not maintainable. Considering an issue of law as contemplated in Order 14 Rule 3, court will hear a particular issue and dismiss the suit, barred by law, barred by limitation, whatever it may be. So, when court has passed an order on a preliminary issue or a single point, then if it allows that appeal, holding that the trial court is not correct, then it can remand it only on that question, because other questions have not been considered. Then it will invoke only Order 41 Rule 23. Whereas in other cases where the trial court has conducted full inquiry, recorded the evidence, oral as well as documents, and has disposed of the suit, then Order 41 Rule 23 capital A comes into picture. Then all these things, framing of issues, additional evidence, all those things will be considered, and then court can remand. These are the two provisions which deals with regard to remand of the case by the appellate court. So next, we will come to 5, question number 5, I think. A ನಮಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ. Even C and D also we have already covered, if you remember. Question number 5, A deals with regard to who are all to be added as parties in a suit for partition. 4 marks. So naturally, in a suit for partition, depending upon the dispute, all the persons who are going to be affected has to be added as parties to the suit of partition. They may be necessary parties or proper parties. Co-persons ಯಾರ್ಯಾರಿದ್ದಾರೆ, ಯಾರಿಗೆಲ್ಲ ಎಷ್ಟೆಷ್ಟು ಭಾಗ ಬರಬೇಕು, ಯಾರಾದರೂ ತೊಗೊಂಡು ಬಿಟ್ಟು ಹೋಗಿದ್ದಾರೋ ಅವ್ರನ್ನ ಪ್ರಾಪರ್ ಪಾರ್ಟಿ ಮಾಡ್ಬೋದು. ಸೊ all those things, all those persons who are interested in the subject matter and who are entitled for relief and from whom the relief is sought for, all of them have to be joined as parties, mean parties. So naturally, the person who is enjoying the benefits, even though he is not having full right, should also be joined as a party, because from him the plaintiff is required to take the mean profits. As far as rights determined in a preliminary decree and final decree, C and D, which we have already examined, in some of the types of cases, as we know, that court is required to pass preliminary decree only, which is contemplated under Order 20 of the Code of Civil Procedure. Suit for partition, specific performance, mortgages, easementary right, mortgages and partnership suits for accounts, all those things. In the preliminary decree, court will just ascertain whether they are entitled for the relief. And by virtue of preliminary decree, if the parties are required to take further actions, then the final decree will come into operation, for which there is no limitation as held by the Supreme Court to file a final decree proceedings. In the final decree, the court will finally adjudicate the rights of the parties and give the relief. Then we will come to the next question paper. I think in that there are no other questions pertaining to CPs that is there. That is question number 13, C and D, C and D, which we have already dealt with, if you remember on earlier occasion. That is, what are the questions to be determined by court executing the decree? That is, question paper 2015, question number 13, Roman 13, C and D. 47 deals with regard to execution, where it says all the questions arising out of the execution should be decided by the executing court only. Only 3 marks are there. So you should mention the power of the executing court, and the executing court normally cannot go beyond the decree, as we all know that. Whatever the decree is there, accordingly the court is required to execute. There may be certain exceptions, as we know that, in which the court can go beyond the decree, when the decree itself is questioned, it is fraudulently obtained, then the court has got power under such circumstances to go beyond the decree and say that yes, fraud has been played in obtaining this decree, that cannot be executed. And it has to decide all the questions arising in that execution. Excessive execution, wrongly executing the decree. If the demolition is not there, if the decree holder under the guise of executing the decree demolishes, there itself he can seek his relief for wrong done by the decree holder. Excessive delivery, 40-30 is decreed, 40-60 is taken. So, section 47 application you can file the JDR and ask the court to direct him to hand over the possession of the excessive portion. As far as questions to be determined on an application under Rule 97 and 99 of Order 21, where it says if the decree holder or the purchaser is obstructed to take possession from the scheduled property, then they can invoke Rule 97. Whereas Rule 99 says, other than judgment debtor, if he is dispossessed from the possession of the scheduled property, he can file an application. No, I have got a right in this property. But he should not be a JDR. JDR has no power to invoke Rule 97. Then only he can. So only 2 marks are there, and the court is required to hear both the sides in both 97 and 99 and record the evidence and pass the order. So now coming to 2016 question paper, this also question number 3 of 2016 question paper. ಯಾವುದರಲ್ಲಿ 15 ಅಲ್ಲ, ಹಾಂ ಯಾವುದು ಹೇಳಿದ್ನಲ್ಲ, ಹಾಂ ಐ ಮೆನ್ಷನ್ C&D ಅಲ್ವಾ, ಹಾಂ ಹೇಳಿದ್ನಲ್ಲ, ವಾಟ್ ರೈಟ್ಸ್ ಆರ್ ಡಿಟರ್ಮಿನ್ಡ್ ಇನ್ ಪ್ರಿಲಿಮಿನರಿ ಡಿಕ್ರಿ. ಇನ್ ದ ಪ್ರಿಲಿಮಿನರಿ ಡಿಕ್ರಿ ದ ರೈಟ್ಸ್ ಆಫ್ ದಿ ಪಾರ್ಟೀಸ್ to get that relief will be determined. For example, partition suit. In a preliminary decree, the court will decide only whether he is entitled for a share in the property or not. That is all. The court will decide in a preliminary decree whether the party has got right as he sought in the suit, and in pursuance of which the parties are required to take further action. ದರ್ ಇಸ್ ಓನ್ಲಿ ಎ ಪ್ರಿಲಿಮಿನರಿ ಡಿಕ್ರಿ. ಅದು ಅದಕ್ಕೆ ಹೇಳಿದ್ದು ನಾನು ಎಕ್ಸಾಂಪಲ್ ಕೊಟ್ಟನಲ್ಲ, ಮಾರ್ಟ್ಗೇಜ್ ಸೂಟ್ನಲ್ಲಿ ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ದ ಕಾಂಟ್ರಾಕ್ಟ್, ಸೂಟ್ ಪರ್ಟೈನಿಂಗ್ ಟು ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಆ್ಯಂಡ್ ಅಕೌಂಟ್ಸ್, ದ ಕೋರ್ಟ್ ವಿಲ್ ಫಸ್ಟ್ ಅಡ್ಜುಡಿಕೇಟ್ ವೆದರ್ ದೇ ಹ್ಯಾವ್ ಗಾಟ್ ರೈಟ್ ಟು ಡಿಸಾಲ್ವ್ ದಿ ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಫರ್ಮ್ ಆ್ಯಂಡ್ ಕ್ಲೈಮ್ ಫಾರ್ ಶೇರ್, dissolution of partnership and accounts ಗೆ. Then the parties are required to take further action. So ಅದು ಪ್ರಿಲಿಮಿನರಿ ಡಿಕ್ರಿ ಆಗುತ್ತೆ ಅಷ್ಟೇ. ಅಲ್ಲಿ ಯಾವಾಗ ದೇ ಆರ್ ನಾಟ್ ರಿಕ್ವೈರ್ಡ್ ಟು ಟೇಕ್ ಫರ್ದರ್ ಆ್ಯಕ್ಷನ್ ಅಂದರೆ ದರ್ ಇಸ್ ದ ಫೈನಲ್ ಡಿಕ್ರಿ. ಸೂಟ್ ಫಾರ್ ರಿಕವರಿ ಆಫ್ ಮನಿ, suit is decreed. Once for all it is over. Whereas in the final decree, how that share has to be taken or ascertained will be determined. In 5 acres of land, 1/5 share is given to the plaintiff by metes and bounds. Preliminary decree is passed. He is entitled for 1/5 share. So to take that 1/5 share out of the 5 acres, court will decide which portion of the 1/5 of that particular 5-acre land should be given to the plaintiff by metes and bounds. So that right will be decided in the final decree. ಯಾವ ಭಾಗ ಕೊಡಬೇಕು ಇವನಿಗೆ ವಾದಿಗೆ 5 ಎಕರೆಯಲ್ಲಿ 5ನೇ ಒಂದು ಪೋರ್ಷನ್ನು ಯಾವ ಭಾಗದಲ್ಲಿ ಕೊಡಬೇಕು. ಸೊ ಆವಾಗ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಫ್ ಕಮಿಷನ್, ಆರ್ಡರ್ 20, ರೂಲ್ 16, ಮೀನ್ ಪ್ರಾಫಿಟ್ಸ್ ರೂಲ್ 12 ಅವೆಲ್ಲ ಬರುತ್ತೆ. ಸೊ ಇನ್ ದ ಫೈನಲ್ ಡಿಕ್ರಿ ಕೋರ್ಟ್ ವಿಲ್ ಅಡ್ಜುಡಿಕೇಟ್ ಫೈನಲಿ what is how the relief has to be given to the party and give the possession, although bifurcate by metes and bounds by appointing a commission. So now 2016, otherly we have already dealt with, if you remember, briefly third question number 3A briefly discussed on the following issues in facts and facts in issue. This we have already discussed, if you remember. Issues in facts. What are the issues in the facts? So issue of fact ಅಂತ ಹೇಳ್ತೀವಿ ಅದನ್ನು. ಆರ್ಡರ್ 14 ನಲ್ಲಿ 2 types of issues and we can add one more issue. One is issue of fact, issue of law, issue of mixed question of fact and law. So those are the issues in fact of a particular case. A material proposition of fact affirmed by one party and denied by another party constitute an issue of fact. That is the issues in fact. So second portion of the question says facts in issue. ಆ ಇಶ್ಯೂಗಳಲ್ಲಿರ್ತಕ್ಕಂಥ ಅಂಶ ಏನು? Whatever the issues that have been framed, in those issues, what are the facts involved? Whether the plaintiff proves that defendant has taken 5 lakhs by executing a promissory note, issue of fact. So now in that the issues in facts are many. How the promissory note loan was given, when it was given, when promissory note was executed, who were there. These are all the facts in issue. Now next to question of law and question of fact. So naturally, as we know that if any question is pertaining to a fact, is question of fact. If it is pertaining to law, it is a question of law. ಅದಕ್ಕೆ ನಾನು ಉದಾಹರಣೆ ಕೊಟ್ಟನು. ಇನ್ ಕೋರ್ಟ್ ಇನ್ಸ್ಟ್ರೂಮೆಂಟು, Section 20 of the Negotiable Instrument Act, where a person gives a blank document signed by him with an understanding that the party to whom he gives can fill up that for a particular amount. That is inchoate instrument, incomplete instrument anta negotiable Section 20 of the, that is recognized by law also now. Decisions are also there. But the person in whose favor that inchoate document is given should only fill up as per the agreed terms for agreed amount, not more than that. So that is whether that is inchoate instrument or not as per Section 20. It is a question of law. Whether a promissory note is materially altered or not as per Section 87. It is a question of law. Question of fact, whether he has executed the document or not. ಅವ್ನು ಮಾಡಿಕೊಟ್ಟಿದ್ದಾನೆ ಇಲ್ವೋ, it is a question of fact. If the ಡಿಫೆಂಡೆಂಟ್ ಡಿನೇಸ್ ನಾನು ಐ ಹ್ಯಾವ್ ನಾಟ್ ಎಕ್ಸಿಕ್ಯೂಟೆಡ್ ದಿ ಪ್ರಾಮಿಸರಿ ನೋಟ್, ನಾನು ಬರೆದು ಕೊಟ್ಟೇ ಇಲ್ಲ ಅವನಿಗೆ, ಅದು ಕ್ವಶನ್ ಆಫ್ ಫ್ಯಾಕ್ಟ್. ನೆಕ್ಸ್ಟು materials on which issues may be framed under Order 14 Rule 3 CPC. ಇದನ್ನು ನಾವು we have covered earlier. To remind you in brief, the Rule 3 gives what are the materials on which the issues have to be framed. Pleadings, that is plaint and written statement, and rejoinder if it is filed invoking Order 8 Rule 9 of the Code of Civil Procedure. Documents produced by the parties. Third one is the answers given by the parties when the court has asked questions to the parties invoking Order 10 of the Code of Civil Procedure. ನ್ಯಾಯಾಲಯಕ್ಕೆ ಅಧಿಕಾರ ಇದೆ ಆರ್ಡರ್ 10ನಲ್ಲಿ ಪಾರ್ಟಿಗಳಿಗೆ ಪ್ರಶ್ನೆಗಳನ್ನು ಕೇಳಬಹುದು. ಆ ಪ್ರಶ್ನೆಗಳಿಗೆ ಅವ್ರು ಕೊಟ್ಟಂಥ ಉತ್ತರಗಳು ಬಿಕಮ್ ಪಾರ್ಟ್ ಆಫ್ ದಿ ರೆಕಾರ್ಡ್ಸ್, and those answers have to be considered while framing the issues. In addition to this, the court has also got power to examine the parties to ascertain what exactly the dispute between them to frame the issues. ಅದಕ್ಕೆ ಅಧಿಕಾರ ಇದೆ ಎಕ್ಸಾಮಿನ್ ಮಾಡೋದಕ್ಕೆ. So these are the materials on which the court is required to frame issues under Order 14 Rule 3. ನೆಕ್ಸ್ಟ್ ಕಮ್ಸ್ ಸಿ, ಇದು ಲಿಮಿಟೇಷನ್ಗೆ ಸಂಬಂಧಪಟ್ಟದ್ದು. ದಿ ಲಿಮಿಟೇಷನ್ ಒನ್ಸ್ ಸ್ಟಾರ್ಟ್ಸ್ ಮೂವಿಂಗ್, ದೇರ್ ಕೆನಾಟ್ ಬಿ ಸಿಗ್ನಲ್ಸ್ ಟು ಸ್ಟಾಪ್ ಇಟ್. ಹೌಎವರ್, ದೇರ್ ಆರ್ ಸರ್ಟನ್ ಅಕೇಶನ್ಸ್ ವೇರ್ ಇನ್ ಸರ್ಟನ್ ಪೀರಿಯಡ್ಸ್ ಆರ್ ಟ್ರೀಟೆಡ್ ಆಸ್ ಗ್ರೇಸ್. ಡಿಸ್ಕಸ್ ವಿತ್ ರೆಫರೆನ್ಸ್ ಟು ಎಕ್ಸ್ಕ್ಲೂಷನ್ ಆಫ್ ಟೈಮ್ and significance of Section 5 of the Limitation Act. So normally it is said under Section 9 of the Limitation Act, once the time starts to run, no subsequent inability or disability will stop it. Disability, minor, insane person. Inability, met with an accident, not well. All these things will not stop the running of the time. Once the time starts to run, no subsequent disability or inability will stop it. ಅದನ್ನು ಬೇರೆ ಅರ್ಥದಲ್ಲಿ ಅವ್ರು ಹೇಳಿದ್ದಾರೆ, ಬೇರೆ ಪದಗಳನ್ನು ಉಪಯೋಗಿಸಿ. ಅದಕ್ಕೆ ನಾನು ಯಾವಾಗಲೂ ಇದನ್ನು ನಮ್ಮ ಲೈಫಿಗೆ ಹೋಲಿಸ್ತೇನೆ. ಇನ್ ಲಿಮಿಟೇಷನ್, there is a different period of time for filing a particular case. So each human being is a separate case. He has got his own limitation. So limitation starts to run. Yavaga for human being, soon he takes the birth. Alva? But nobody knows what is the limitation for the particular person. But there is a period of limitation which comes to an end. So within that only he has to achieve whatever